Today on Inside the Issues, we talk with Andrew Thompson on human rights governance. Welcome to Inside the Issues, a podcast of the Centre for International Governance Innovation in Waterloo, Ontario. I'm your host, David Welch. I am the Balsillie School's CIGI Chair of Global Security. Every week, I have the pleasure and privilege of talking to an expert in some important issue area of global governance, and I'm joined this week by Andrew Thompson, Adjunct Professor of Political Science at the University of Waterloo, and also the Global Governance Program Officer here at the Balsillie School. Thanks for joining us this week, Andrew.
Thanks for having me.
We're going to talk today about human rights. That's your particular area of research expertise, and in particular, we're going to talk about human rights governance. Right. So, human rights from a global perspective, but if possible, I'd like to focus in on a couple of countries' human rights policies as well. But let's start off by let me ask you, what's your general characterization of the state of human rights governance today, globally?
Globally, it's actually, we have quite a robust system. We have a lot of international human rights law at the international level through the UN, but also at the regional level. The OAS, for instance, has a very, very extensive human rights system that actually predates the UN's system, and of course Europe has a very robust system as well. We also have human rights enforcement at a lot of levels, and most countries have human rights commissions. Judiciaries are often very active in enforcing human rights law, domestic human rights law. And then at the international level, we have mechanisms like the International Criminal Court, the High Commissioner for Human Rights, special rapporteurs. So there is actually, a very extensive and elaborate human rights system that works on many levels. The problem is in the consistency of enforcement. And in fact, while we have these universal norms relating to human rights, not everyone enjoys rights to the same degree. And this has been the problem with the international system really since the founding of the UN, is the inequitable protection of human rights around the world.
So if we look just at the laws, the regulations, the institutions, it's easy to see that there's progress. Fairly rapid progress.
Absolutely. And
fairly steady progress, too.
Absolutely. And in fact, scholars talk about generations of rights. And the thinking, and this is contested thinking, but the thinking is that there are first-generation rights, which are political and civil rights. These would include things like freedom of expression, freedom of association, freedom of religion. And then the second-generation rights would be economic, social, and cultural rights. And then, really beginning in the 1960s, with the various civil rights movements, women's rights movement, Aboriginal rights movements, etc., we saw the emergence of what are called third-generation rights, which are essentially group rights, in which a particular segment of society is identified as being in some way special and in need of special, distinct rights because of their identity. And so we actually have quite a lot of international law that deals with these various generations of rights. Again, the problem is with enforcement, and some countries prioritize certain rights over others. And for much of the Cold War, for instance, countries in the West really were very, very reluctant to acknowledge economic, social, and cultural rights as legitimate rights. And in fact, there was a lot of baggage. They were considered communist rights.
Right. I see. And who's been driving this progress? Is it states? Is it civil society actors? Is it individual people, entrepreneurs who are out there trying to raise consciousness and name and shame governments and so forth?
I think it's all of the above.
All of the above.
And definitely, a lot of the advances in human rights, whether it's in terms of new human rights norms or new enforcement mechanisms, have been pushed by civil society actors, and either NGOs, religious groups, or in some cases, prominent individuals who see a particular injustice and act on it. But I wouldn't discount the role that states have played in advancing ideas as well. And I'll give you a very good example. In 1953, the United States began the session of the UN Human Rights Commission, which was the body that was responsible for drafting international law and essentially setting standards for the international system. In 1953, the United States began the session by saying, we're no longer going to sign and ratify the two international covenants, the first being the Covenant on Civil and Political Rights, the second, the Covenant on Economic, Social, and Cultural Rights, which together are really the basis of the international human rights system. And so the delegate from Uruguay got up and he said, well, if the most powerful country in the world is not going to take international human rights law seriously, then we need to take other steps to enforce human rights, and proposed the idea of a High Commissioner for Human Rights in 1953. And of course, this position isn't actually created until 1993, after the Cold War.
It took a while.
It did.
This may be hard to answer, but we can easily see a proliferation of rules and norms and expectations.
Right.
What about observance? Is it possible to look at the world today and say, actually human rights are better respected, on balance, than they were 100 years ago? Or is it just impossible to tell empirically?
No, I think you could make some kind of claims like this. For instance, the death penalty is a good example. Even 10 years ago, in the early 1990s, more than half of the world practiced capital punishment. Today, international law is definitive in prohibiting capital punishment, and the majority of the world's states no longer have it in their criminal codes. And in fact, we are on a path towards, one day having probably total abolition of capital punishment.
Although two of the laggards in that respect are our friends and neighbors, the United States, and of course China, both of whom have capital punishment in their criminal codes.
Yes, there are some big exceptions.
Important exceptions.
To this. But I think it depends on the right that we're talking about, and definitely, I think a strong case could be made that we've seen a rise in torture since September 11th. And what we thought was a fairly strong taboo against torture prior to 9/11, we now see that when faced with the threat of international terrorism, governments are rethinking that taboo.
Right. Well, fascinating. We'll be back again in a minute with Andrew Thompson. You're watching or listening to Inside the Issues, a CIGI Online podcast. You can find us at cgonline.org, on Facebook, on YouTube, and on Twitter. Now, you mentioned in the earlier segment that there are three generations, generally considered three generations of human rights, political, civil, economic, social, and now group rights of various kinds. Arguably, they're not always consistent. In other words, promoting one set of those rights might lead to violations in another set of rights. Some groups, for example, would argue that cultural security, the acknowledgement and protection of their rights as groups requires that they be allowed, for example, to discriminate between men and women, right. To prevent women from driving cars or voting, and so forth and so on. How do we negotiate tensions between these various generations of human rights? Or is that just an ongoing battle? We'll never solve it. We'll just have to make do as we can as we go along.
Well, I think one of the premises of the human rights movement or system, which really doesn't hold up, is the idea that rights are indivisible, that each right is equal to the next right. And we talk about these terms all the time, the indivisibility of rights. It's in international law, but of course, as you note, that rights sometimes collide, and you see this quite starkly in the cases involving, say, religious freedom and cultural rights, or the rights of women versus religious rights, etc. And every society has to negotiate the proper balance. And in Canada, for instance, these rights are not absolute, according to our Charter of Rights and Freedoms. And typically, in liberal democracies, the balance has swung towards the individual. And so the test is that essentially if a particular practice infringes upon the security of the individual, then that is grounds for curtailing it or for it not being absolute. But these are very, very context specific. And one of the things about human rights is that our interpretations of rights and our acceptance of various rights principles is constantly evolving, and not in a linear way. Often, again, going back to the example of torture, before 9/11, we thought that in fact there was a fairly well-established taboo against the use of torture, and of course now we're finding that that's not the case. And so every society has these discussions about trying to manage rights that are seemingly at odds with each other.
And does the rise of, or the resurgence of torture since 9/11 indicate that human rights are really thought of by states as luxuries, things that you can indulge in peaceful times, in good times, but in hard times, they're expendable? Human rights can't, in fact, compete with other demands such as national security, counterterrorism.
I think there's a natural inclination on the part of states and publics to see human rights principles and security as being mutually exclusive. And if we look at the debates right after September 11th with respect to our anti-terrorism legislation, our national immigration security certificate system, for instance, the issue was about balance. How do we find the appropriate balance between respecting rights on the one hand and protecting public safety on the other, which is a legitimate pursuit for the state? But that debate rested on the premise that the two are mutually exclusive, the logic of balance, essentially, when in fact what many human rights advocates were arguing at the time was that human rights and national security don't have to be mutually exclusive and can in fact reinforce one another. But what that means is that when you're developing anti-terror policies, you follow due process. And all of your policies have human rights concerns at the center, so that in fact, you don't create a system in which basically expediency takes precedence over all other concerns. And what human rights do is they essentially provide guidance for policymakers on what is morally permissible when dealing with these very, very difficult issues.
And would you agree with some of the key human rights organizations that there is in fact no real trade-off? I mean, defenders, for example, of the Bush administration's strategy after 9/11, right, interrogations at Guantanamo Bay and so forth, they would say, look, waterboarding may have been a really awful thing to do to somebody, but it yielded information that in fact prevented terrorist attacks. So there is a trade-off, and you do have to make the choice, which is going to be more important. Do you think they're just wrong? We can't tell because
right,
they won't share the information with us, right? They won't tell us which attacks they thwarted and trot out the evidence.
Absolutely, and there were a lot of people, particularly in the United States, although not exclusively, after September 11th, who were in fact making that very argument, and it's kind of the ticking time bomb scenario. Critics of that have suggested that in fact, torture is a very, very blunt way of getting information out of someone. It's very unreliable, and that there are in fact other techniques that can be used that can garner the same result. And that basically, governance is about choice. And when confronted with very, very difficult situations that do involve national security, one of the things that human rights do is they can in fact help guide those particular policy choices so that we avoid situations like the practices at Guantanamo Bay, which have become a real difficult situation for the Obama administration, which, as we know, would like to close the prison but doesn't know how.
Although arguably the backlash against practices there may promote human rights by further delegitimating torture practices. But I guess we'll have to wait and see.
We'll have to wait and see.
That's true. We'll be back in just a minute once again with Andrew Thompson. You're watching or listening to Inside the Issues, a CIGI Online podcast. You can find us at cgonline.org, on Facebook, on YouTube, and on Twitter. Andrew, let's talk a bit about Canada. Is Canada a human rights entrepreneur? Are we in the forefront of countries promoting human rights?
I think, traditionally we have been, at least since in the last 30 or 40 years. Interestingly, when the UN human rights system was being founded in the 40s and then 50s and 60s, Canada was actually quite reluctant to get involved with the debates around human rights. We did not participate on the UN Human Rights Commission. We actually abstained from voting on the Universal Declaration of Human Rights when it was being voted on in the Third Committee of the General Assembly. And this was on December 6, 1948. And we were the only Western government not to vote in favor of the declaration.
And what was our excuse there?
Well, the excuse given at the time, which was a legitimate concern, was that many of the rights found in the declaration actually involved provincial areas of jurisdiction, and that the federal government was quite reluctant to agree to rights conditions that it would involve the provinces. Even though the Universal Declaration is a non-binding document, it is simply a statement of principles. And so we found ourselves in the company of the communist or the Soviet bloc countries, plus Saudi Arabia and South Africa. And so 4 days later, when the vote went before the General Assembly, we changed our position and we voted in favor of it. But even throughout the 1950s, Canada was very reluctant to be involved. We were particularly nervous about issues involving racial equality because of our own election practices and immigration policies. Then in the 1960s, something changed, and 1960, Diefenbaker brought in the Bill of Rights, and the British Empire, of course, was no longer around after the Suez Crisis of 1957, and Canadians started to embrace the idea of rights. And prior to that, we'd seen ourselves as essentially subjects of the British Empire, at least in English Canada, and rights were seen as something that were very American and not part of our political tradition. This changes in the 1960s, and particularly in the 1970s, there's a new wave of diplomats that come through the Department of Foreign Affairs, and Canadians domestically are starting to call for greater rights in Canada, and we start to see Canada really championing things like freedom of expression, women's rights abroad, and even for many years was, we were quite active internationally on Indigenous people's rights. And then, of course, during the 1990s, during the heyday of the human security agenda under Lloyd Axworthy, Canada was very, very active in the creation of the International Criminal Court and advancing new norms in international law relating to the protection of civilians during armed conflict.
What about in recent years? Has Canadian foreign policy paid attention to human rights? Have we been in the forefront of progressive change?
I think in recent years there's been a lot of questioning as to whether or not Canada is still a leader on human rights. And for instance, that Canada was very, very heavily criticized for not voting in favor of the Declaration on Indigenous Peoples in 2007. And just recently, a few weeks ago, Canada did change its position and voted in favor of it. But for instance, that was a document that had been negotiated at the UN for about 30 years. I mean, it was a very slow piece of international law. But Canada had been very active in the negotiations. And then for the government not to vote in favor of it, even though, again, it's a declaration and is not legally binding, was seen by a lot of Aboriginal groups as being a real slap in the face. And again, another example of broken promises. On Other issues, like capital punishment, for instance, the Canadian government recently announced that it would not seek clemency for Canadians who were set to be executed if the country they were being held in was a democracy. And of course, this was challenged in the courts, and the government lost that case. And so many people have seen recent foreign policy as eroding human rights standards and Canada's leadership abroad.
How about our domestic affairs? Are we leading by example at all? You could make the argument, I guess, that in Canada we're a microcosm of all three generations of human rights interacting. We do have freedom of speech and freedom of religion. We have those sorts of individual civil and political rights, I guess, for want of a better term. We have universal health care, and we've got a social safety net that's the envy of much of the world. Right. So economic and social rights seem to be of major concern here in Canada. And then we pride ourselves on effective multiculturalism. We try to find ways of reaching reasonable accommodation with historically illiberal communities, which would indicate a concern for group rights. So we seem to have this clash of all three here at home. How are we doing?
Well, and I think on balance, I think much of the world would say that Canadians enjoy a lot of rights, and perhaps we take it for granted. That being said, the protection of rights, even in liberal democracies such as Canada, that have a strong tradition of rule of law, that have constitutional charter of rights and freedoms, that have a strong judiciary that is willing to enforce and even make human rights law, and we have a very active human rights civil society. Despite all of that, there is evidence that, in fact, rights principles, standards in international law have not been followed in recent years. And it is a constant struggle to, in fact, ensure that our policies live up to these
Which ones
ideals.
in particular have we not been living up to?
Well, I mean, there's been a lot of controversy around our refugee policies, and these are not new. I mean, these date back to the 1970s when the new Immigration Act was brought in that actually identified refugees as a special class of individuals. But what we've seen in recent years, particularly after September 11th, is an assault upon due process relating to the refugee determination system. And in fact, one of the arguments for this is that, in fact, the refugee system is a potential security vulnerability for Canada, that would-be terrorists could enter the country through our refugee determination system. There have also been arguments made that, in fact, freedom of expression is under assault in Canada, and that there's what we're in fact seeing is in effect a chill effect in place where people are engaging in self-censorship because of the perceived penalties involved in speaking on particularly controversial issues.
You're thinking of the hate crimes laws in Canada.
Exactly.
Right.
Exactly. So, one of the things about human rights is that these are ideals to which we aspire, but in practice, it's rarely cut and dry. And all of these issues involve very, very difficult and complex considerations.
They certainly do. We'll be back again with Andrew Thompson. You're watching or listening to Inside the Issues, a CIGI Online podcast. You can find us at cgionline.org, on Facebook, on YouTube, and on Twitter. Andrew, we read in the newspapers from time to time that a country such as Libya or Iran is on the verge of gaining a seat on a Human Rights Council.
Right.
What do we do about the fact that human rights pariahs seem to claim the right and the privilege of actually sitting on panels such as that? And is that general illustration of a cynicism about human rights governance in the world, or is this just something we have to figure a way to manage?
Well, I think there are a couple of ways of looking at it, and definitely in 2006, when the Human Rights Commission was dissolved and replaced with the Human Rights Council, the primary reason for it was that it had lost legitimacy because human rights pariahs had gained membership on the commission and had used their position there to essentially block any criticism of their own practices or the practices of their allies. And so there was a general discrediting of the entire UN human rights system as a result. Unfortunately, with the Human Rights Council, we've seen the same practices taking place in which countries are using their membership on the Commission to block criticism. The thing to note, however, is that in fact, at various points, all countries engage in this particular practice. And one of the things about the Commission that led to its downfall was that it was actually working, that it was serving as a forum in which governments were being shamed for their human rights record. And so it was, in a kind of perverse way, a victim of its own
Shut
success.
down because it was working.
Exactly, on one level. And so, this is something that I think is one of the realities of the UN human rights system, that countries will go out of their way to avoid being criticized. And Canada doesn't like to be criticized internationally. The US doesn't like to be criticized internationally. I mean, I think it's natural for states to try and mute.
But naming and shaming is a key element of human rights progress, I would imagine.
Absolutely.
So the action shifts then to civil society actors, NGOs, celebrities in some cases.
Absolutely, and in fact, many human rights scholars have argued that in fact the UN system was working because it allowed for civil society involvement in the process, and groups like Amnesty International or Human Rights Watch, who could in fact point the finger at particular countries and for their domestic practices and really put them in the hot seat. The thing to keep in mind, however, with the Commission, now the Council, is that this is a dialogue about rights as well. And for much of the history of the Human Rights Commission, it was dominated by the Western powers who, in many respects, were very, very insensitive to the human rights priorities of countries in the South. And I mean,
The economic and social rights.
or even issues of racial equality as well. In the 1960s, for instance, the issue of apartheid in South Africa was of huge importance to much of Asia and Africa. And governments in the West were very, very reluctant to engage with that issue and saw these governments as being problematic for raising it. And so I think part of the story is, countries actively obstructing criticism of their own practices. But on another level, it's also a contest of priorities and a discussion about, what are in fact the norms that should be privileged. And often we've seen a great divide in the between the North and the South on what in fact constitutes a real human right.
Right. So what needs the most attention today? If someone came to you and said, help us shore up gaps in the global human rights governance regime, what would you point to? What kinds of institutions or norms or practices would you argue for?
Well, I think at the international level, as I've mentioned before, we actually have a really robust system. We have the Office of the High Commissioner for Human Rights. We have the International Criminal Court. And these institutions can all be strengthened. I mean, there's a lot that can be done to improve them. But one thing that a number of activists have called for is, in fact, universal legal aid. And that if you were to offer victims of human rights abuses the financial means to gain access to the justice system, then that's probably going to do more for the advancement of human rights than any of these very high up institutions like the International Criminal Court. And what's needed, I think, is more emphasis on the the local and allowing populations that are marginalized and disenfranchised access to justice. And that's hard, and that requires a lot of resources, and it requires a functional judicial system, which many countries simply don't have the resources for. So, but that, I think, if we were very serious about equal enforcement of human rights principles around the world, legal aid would be a great first step.
So progress on global human rights governance requires progress on domestic governance around the world.
Absolutely.
Very good. Well, thank you very much, Andrew Thompson, for coming in and talking to us today about human rights. I'm David Welch. This has been Inside the Issues, the CIGI Online podcast. Please visit us again next week, and visit us also online at cgonline.org, on YouTube, on Facebook, and on Twitter. Today on Inside the Issues, we talk with Andrew Thompson on human rights governance. Welcome to Inside the Issues, a podcast of the Centre for International Governance Innovation in Waterloo, Ontario. I'm your host, David Welch. I am the Balsley School's CIGI Chair of Global Security. Every week, I have the pleasure and privilege of talking to an expert in some important issue area of global governance, and I'm joined this week by Andrew Thompson, Adjunct Professor of Political Science at the University of Waterloo, and also the Global Governance Program Officer here at the Balsley School. Thanks for joining us this week, Andrew.
Thanks for having me.
We're going to talk today about human rights. That's your particular area of research expertise, and in particular, we're going to talk about human rights governance. Right. So, human rights from a global perspective, but if possible, I'd like to focus in on a couple of countries' human rights policies as well. But let's start off by let me ask you, what's your general characterization of the state of human rights governance today, globally?
Globally, we have quite a robust system. We have a lot of international human rights law at the international level through the UN, but also at the regional level. The OAS, for instance, has a very, very extensive human rights system that actually predates the UN's system, really since the founding of the UN, is the inequitable protection of human rights around the world.
So if we look just at the laws, the regulations, the institutions, it's easy to see that there's progress. Fairly rapid progress.
Absolutely. And
fairly steady progress, too.
Absolutely. And in fact, scholars talk about generations of rights. And the thinking, and this is contested thinking, but the thinking is that there are first generation rights, which are political and civil rights. These would include things like freedom of expression, freedom of association, freedom of religion. And then the second generation rights would be economic, social, and cultural rights. And then really beginning in the 1960s, with the various civil rights movements, women's rights movement, Aboriginal rights movements, etc., we saw the emergence of what are called third generation rights, which are essentially group rights, in which a particular segment of society is identified as being in some way special and in need of special, distinct rights because of their identity. And so we actually have quite a lot of international law that deals with these various generations of rights. Again, the problem is with enforcement, and some countries prioritize certain rights over others. And for much of the Cold War, for instance, countries in the West really were very, very reluctant to acknowledge economic, social, and cultural rights as legitimate rights. And in fact, there were system, and of course Europe has a very robust system as well. We also have human rights enforcement at a lot of levels, and most countries have human rights commissions. Judiciaries are often very active in enforcing human rights law, domestic human rights law. And then at the international level, we have mechanisms like the International Criminal Court, the High Commissioner for Human Rights, special rapporteurs. So there is actually, a very extensive and elaborate human rights system that works on many levels. The problem is in the consistency of enforcement. And in fact, while we have these universal norms relating to human rights, not everyone enjoys rights to the same degree. And this has been the problem with the international